Thank you, Mayor. I'll just take a few minutes and explain the council's role on this appeal of a decision that the Planning Commission made at its September 1st, 2010 meeting. I provided a memo to all the members of the council that kind of outlines what your role is and
Appreciate that, by the way. Very helpful.
you're welcome. And so I'm just going to, kind of go through that memo and highlight the key portions of that. This is an appeal. In North Ogden, the Planning Commission has been designated as the Land Use Authority. They're the body that makes the decision, the first decision regarding conditional use permits. Generally speaking, a conditional use is a use within a zone that may or may not be appropriate depending on its specific location, but it may not be appropriate everywhere. It may be appropriate if you can apply certain conditions to mitigate the effects that it has on surrounding property. Generally, conditional uses, that's what they're aimed at, is they're uses that in some places may be just fine, but in other uses they may have negative impacts on the property around them. And then the question becomes whether you can satisfactorily deal with those negative impacts by imposing conditions. So the Planning Commission went ahead and granted this conditional use permit for a auto repair business that was to be operated out of a residential garage at 3590 North, 575 East here in North Ogden. The City Council is designated as the appeal authority for that decision, and an appeal by an affected resident has been made, so that's why you're hearing this tonight. The standard of review is what's called de novo. That means that you're not bound tonight by anything that any findings that the Planning Commission made or their interpretation of the city code. You look at this with a set of fresh eyes, listen to the arguments on both sides of the issue, and make your own decision. The person who's appealing the decision of the Planning Commission has what's called the burden of proof, and that means that if you were to decide that the evidence on both sides of this issue were equally weighted, then the tie would go to upholding the decision of the Planning Commission. Because this is sometimes when the City Council makes decisions, often when the City Council makes decisions, for example, when you're enacting a zoning ordinance or enacting any ordinance, you're acting or setting budgets, you're acting as a legislative body. You have a lot more discretion when you're acting as a legislative body. Tonight, when you're acting as an appeal authority, you're sitting as a quasi-judicial body, and your role is more narrow, and that is to weigh the evidence that's presented to you. And your decision has to be based on the evidence. There has to be substantial evidence to support your decision. And in that regard, as I pointed out in my memo, it's not a contest of how many citizens are for it, or how many citizens are against it, or which group is the loudest. You need to make your decision based on the facts. And in this case, the important facts are what are the reasonably foreseeable negative impacts that this use could create for the surrounding neighborhood, and are there reasonable conditions that could be imposed to mitigate those conditions so it's not going to impact the neighborhood. Generally speaking, under state law, if an applicant or a particular use of property can demonstrate that their intended use meets the city zoning ordinance, they're entitled to approval of the use. city code actually kind of mirrors what the state law says about conditional uses. I'll just read that. And then it kind of explains what a conditional use is, under what conditions you're compelled to grant them, under what conditions you have the right to deny them. I've also provided in the memo a number of standards that are in the city code that relate to conditional uses. And also, this is kind of a mixture because it's actually an application for a home occupation. And in North Ogden, the zoning code allows home occupations to be carried on in the garage. So that's kind of the provision that this particular property owner applied under, was as a home use. However, or a home occupation. However, the code says that if the home occupation is going to be carried on in the garage, then it has to be treated like a conditional use. That's why it's before you. It's kind of a mixture of the two. So here's what the code says about conditional use. A conditional use shall be approved if reasonable conditions are proposed or can be proposed to mitigate the reasonably anticipated detrimental effects of the proposed use in accordance with applicable standards. Okay, so that kind of explains when you have to grant the permit. And then it says if the reasonable anticipated effects of a proposed conditional use cannot be mitigated by the proposal or the imposition of reasonable conditions to achieve compliance with applicable standards, the conditional use may be denied. So that's your task, is to consider how this use might negatively impact the surrounding neighborhood and to determine whether there's reasonable conditions that could be imposed to mitigate those negative impacts. And I'd be happy to answer any other questions.
Greg Barker, could you then give us a synopsis of what's brought us to this point?
Thank you, Mayor. Take about 2 minutes, 3 minutes to give a synopsis of what took 3 or 4 hours at the Planning Commission. So I believe you all had the opportunity to read the Planning Commission minutes of the public hearing and also the discussion. We actually had two meetings like you often do on September 1. That's actually when they had the public hearing. And on September 15 is when they had their own discussion. There was actually a meeting prior to the public hearing where this was originally introduced to the Planning Commission. And as a conditional use, they have an option of deciding whether or not to have a public hearing, and they decided that they would. And that started that whole process. And when the public hearing was held, we have on record 32 names of people who attended that hearing to voice or to listen, or they could actually even been there for other subjects. But we actually had 32 people listed as being at the Planning Commission meeting. If you follow the minutes, I originally got up and spoke briefly to the commission, informed them that they were acting as the land use authority. They were going to take action on a conditional use permit. As the attorney has said, they had some general guidance as to what conditions they could require, and they could impose other requirements as they felt necessary if they felt that they could mitigate the adverse impacts of the proposed conditional use. There were a number of people who got up and spoke on behalf of the applicant. Many of them were not immediate neighbors. They were generally in the area, but we had people come far as West Haven who had brought their automobiles to be worked on by the applicant.